Awesome. Thank you, Rina. Hi, everyone. My name is Tauhida Wahabzada. I am one of the co-founders of Onward. I want to first introduce our organization. Our network for the well-being and advancement of relocated dreamers, also known as Onward, is a volunteer-run network focused on developing a community and support network for dreamers and DACA recipients who left the U.S. We hope to cultivate a strong global community where we provide emotional support, career networking for dreamers and DACA recipients who left the U.S. As a volunteer-run organization, Onward does not provide legal advice, and the co-founders and members of Onward are not legal experts. We therefore encourage you to speak to an immigration attorney when taking consideration of legal factors. That being said, today we are hosting an event with Rina Gandhi, Esquire, a partner at Murray Osorio, a full-service immigration law. Rina will present general information about unlawful presence and who it applies to, information about leaving the U.S., legal routes of returning to the U.S., and general information. The event will start out with a presentation followed by a Q&A session. The presentation will be recorded. However, the Q&A session will not be recorded so that participants can freely and comfortably ask questions. During the presentation, please keep your mics muted until our Q&A session. Rina, the floor is all yours.
Thank you so much. So I think when we're first talking about leaving the United States, we want to see, of course, are we actually needing to leave the US, or is there something that can be done here to obtain status? So first, you want to look at if there are any pending cases. Sometimes immigration cases can take many years. A U visa is over 10 years. Family-based cases can be, 10, 15 years. So is there something pending now? Talk to your parents, talk to your family, see if there's something that has been filed in the past and what is the status of that. There are some old laws that may be beneficial to you. There's something called 245I. 245I is an old law that applies where a person themselves or as a derivative. So for dreamers, it would probably be their parents. So if their parent was here in the US on or before December 20th, 2000, and someone, a company, a family member, someone filed a petition for them on or before April 30th, 2001. If that's the case, let's say a parent had their US citizen sibling sponsor them, and the child was either, the dreamer was either born at the time or born later, they could benefit by being grandfathered in under 245I. If you are a beneficiary of 245I, what does that mean? It means that it would forgive unauthorized work, an unlawful presence. So if, for example, a company wanted to sponsor you and you had 245I eligibility, even though technically if a company sponsors you, you need to be in lawful status now, because of 245I, you may not need to be. So it's worth talking to your family before you go. Alternatively, is there a way that you can obtain some lawful pathway now? For example, with DACA, can you get advanced parole? Would that give you a lawful entry that might open the door to apply for something through a family member or the like? What about military parole in place? Military parole in place is available for people who have a immediate relative, so that's typically their spouse, their parent, a child. In some cases, a sibling, but probably not, is in the military, either active duty or honorably discharged. And the military meaning Coast Guard, Army, Navy, any of the US military, you can receive, or the relative can receive parole in place. Parole in place just meaning you get a parole entry without needing to physically leave. That's the in place part of it. So is there a way to get some kind of lawful entry in order to be able to apply for something else? If you were to leave, does that mean whatever you have pending would no longer be available to you? That may be a consideration to take. For example, SIJS is something that you could only do here in the US. If you leave, you cannot continue to benefit from SIJS. SIJS being special immigrant juvenile status. So for somebody who in some states are under 21 or in other states under 18, is able to, or who had, if you're now older than that, had a custody order finding that you had been abused, abandoned, or neglected by one or both parents, and you have a pending SIJS case, you're waiting for a visa number to become available. If you leave, whether it be for a good reason or because you need your freedom, a job or whatever the case may be, you cannot continue to benefit from SIJ. Other petitions, though, you could continue to benefit from abroad. U visa, family-based I-130s, I-730s for parents who got asylum, maybe. So those are some things to keep in mind. Other things to keep in mind are what are the consequences if you do leave? So if you leave and you have a criminal issue, a crime involving moral turpitude, you may not be able to come back or may require a waiver in order to be able to come back. There are things to keep in mind that may avoid a waiver being needed, such as a petty offense exception. So if you have one and only one CIMT for which you received a sentence of under 180 days and the maximum possible sentence is 1 year, you could not need a waiver because it's automatically waived under the petty offense exception. Similarly, juvenile offender exceptions. If you're under 18 and charged as a juvenile, it doesn't count against you. Are there fraud issues to consider? This is something that we would see more often than criminal issues with our dreamers. Unfortunately, did your parent maybe obtain a fraudulent visa in order to get you into the US? When you were young and starting to work, did you accidentally claim to be a US citizen on one of your I-9 forms? The fraud on the visa issues, we often see that. Usually it's not an issue, especially if you're under 14 when that happened, because you're a kid, it's not your fault. Something that you have to report and provide that false name that was used. But the actual misrepresentation really can't be held against you because you were a kid. False claim to citizenship, though, is a pretty harsh, non-waivable issue. So you do have to pay attention and be thoughtful about that. Usually we see that on I-9s or mortgage applications or like FAFSA, so students applying for school. Another thing to consider before you leave is, do you have a removal order? Have you ever been ordered removed, to be more specific? Well, by leaving, you're effectuating that removal order and you're incurring the bar on being able to return. Or do you have pending removal proceedings? In which case, maybe do you want to try to close out that case? Currently, in this kind of environment and administration, we can pretty easily, depending on the facts of the case, dismiss or terminate. So at least when you leave, you're not incurring another bar. Or perhaps we want to ask for voluntary departure if they won't agree to dismiss or terminate. And that way you have kind of a clean exit and you have one less thing to worry about, to deal with when you return. And most commonly, unlawful presence. So for unlawful presence, we're specifically talking about the time after April 1st, 1997. That's when the law kind of changed and went into effect. And so we're only looking at unlawful presence after that time. We're also only looking at unlawful presence for somebody who's over 18. So if you're 18 or under, under 18, then your unlawful presence doesn't count against you. 18 or over, your unlawful presence starts to accrue for the purposes of the inadmissibility ground. But keep in mind that if you have certain things pending or approved, you may not have unlawful presence during that time period. So for example, if you have a pending asylum case and you have not worked without authorization, from when you file that asylum case until a final decision is made, you have no unlawful presence during that time. Now, obviously, if you've gotten a decision, you start to accrue again. If you have a pending adjustment of status case, or you are a derivative with a pending adjustment of status case on maybe your parents' employment-based case, during that time that 485 is pending, you do not accrue unlawful presence. Specifically, you do not accrue unlawful presence while you have DACA. So this is different than TPS. TPS, you don't have unlawful presence from when you file, assuming you're approved, until it expires. For DACA, it's only for the period in which you got it. So not from when you filed. So we know back in, was it like 2017, 2018, wait times were very, very long to renew DACA. So there are some people who, unfortunately, even though they did everything right and filed timely and all of that, have an unlawful presence period in between. So if you have more than 6 months, but less than 1 year of unlawful presence, keeping in mind all these other factors, so adding it up in accordance with these other factors, if you have more than 6 months, but less than 1 year, you have a 3-year bar that is initiated or triggered when you depart the United States, and not until then. The 10-year bar is for when you have 1 year or more of unlawful presence. Now, you may have heard in the news something about, oh, unlawful presence was fixed or something. This kind of misinformation came out of clarification of a policy that we always kind of knew was true. So if you occur a 3 or 10-year bar, you have unlawful presence and you leave, and then you come back with a visa, that bar continues to run. So for example, if you leave January 1st, 2024, and you've got a 10-year bar, but then June 1st, 2024, you got a visitor's visa approved with whatever waivers and things you needed, and you lawfully, properly entered the US, your 10-year bar continues to run. You don't have to kind of start over or anything like that. Then we have a different type of bar that's much more serious. We call it the permanent bar because it's in effect permanent. It never goes away, and it's not waivable for 10 years. So what does that mean? That means from when you depart, before you ask and you apply for the waiver to ask to come back, you must be outside of the US for 10 full years. Okay, doesn't matter if you get a visitor's visa, lawfully, you told the truth, you got the waivers, all of that, and you enter. If you have the permanent bar, you are not supposed to enter. Okay, so how do you get a permanent bar? Most commonly, you get it by being in the US unlawfully for more than 1 year. In this context, your age does not matter. Okay, in this context, you could be 1 year old. It does not matter. Right? That's the really unfortunate part about this bar. You could have done it when you have no knowledge or consciousness or choice in the matter. But you have a year of unlawful presence, you depart, and you unlawfully re-enter. Unlawfully re-enter, right? So earlier I mentioned it doesn't matter if you got a visa and you came back. So if you had occurred have 1 year, you departed, and then you came back with a visa, that's not accruing a permanent bar, and that's not incurring a permanent bar. But if you, let's say, accrued 1 year, departed, re-entered unlawfully, departed, got a visa and came back, I mean that visa and coming back does not allow that 10-year permanent bar where you have to be out of the US to continue to run. So you have to wait the 10 years first before you try to come back. Okay. Another way to incur this bar is by having been ordered removed, departing, and then entering unlawfully again. I have a note here and I want to kind of make sure it's clear. So this note says you may, if you enter lawfully, like I mentioned, with a visa, so let's say you have a year, you depart, but you come back with a visa, you don't come back unlawfully, that does not incur the permanent bar. But how did you get that visa? Because you couldn't have gotten that visa if you fully told the truth, right? Unless the consulate messed up, which is possible, but realistically, there's something that was missed. So maybe there would be a finding of misrepresentation instead. So what can you do if you have any of these issues? Well, if you have unlawful presence, specifically talking about trying to immigrate back to the US, okay? So if you're trying to come with a non-immigrant visa, we'll talk about that later. If you're trying to immigrate to the US and you have unlawful presence, there is a waiver available. However, that waiver is only accessible if you have a US citizen or legal permanent resident, spouse, or parent, not child, notably. So what is that? So there's something called a 601 or sometimes a 601A if you're still in the US, where you are asking for forgiveness to overcome that bar, that 3 or 10-year bar, because your spouse or parent will suffer extreme hardship if you are not in the United States with them. Misrepresentation has a similar requirement, same form. Note, it cannot waive a full claim to citizenship. You still need a US citizen or legal permanent resident spouse or parent, and you're essentially asking for forgiveness for whatever the misrepresentation was made. Note that that misrepresentation has to be your misrepresentation, right? So we talked about if you had a fake visa, but you came when you were 3, that's not your misrepresentation. You don't need a waiver for that. For crimes, if you have a waivable crime, which not all crimes are waivable, but if you have a CIMT or 2 CIMTs, you can use a spouse or parent or child. Interestingly, for crimes, we include children as someone who can show that they will suffer extreme hardship if you're not here. Or in the alternative, that crime occurred more than 15 years ago. For a removal order, for one removal order, within 10 years, you would need a waiver, but you don't need a qualifying relative. You just have to show that, on balance, you are, a good person and you are not a risk to society, etc. Permanent bar, after those 10 years, then you can apply to seek reentry. And then at that point, it's not a, you don't need a qualifying relative, it's a balancing test as well. Okay. All right, so let's talk about what most dreamers, I think, are looking forward to doing, or at least the ones that have come through our office. So we see people who are looking to come as non-immigrants. So for a non-immigrant, we're still subject to the inadmissibility grounds, but there's not the same waivers available. Instead, there's a very almost generous blanket waiver. We call it 212D3, or you may have heard it called a Haranka waiver. So things to consider. Can you enter the US? Do you have something that is waivable? Do you need a visa? For example, from Canada, if you're a Canadian citizen, you don't actually technically need a physical B1, B2 visa. You still can't enter the US though without this waiver. So you would need to process the waiver in Canada. Other countries, depending on their requirements, you would need to seek the visa and at that time apply for the waiver in order to be able to enter. This 212D3 is very broad. Essentially, as long as you're not like a murderer, terrorist, or a risk to national security, you can generally waive whatever needs to be waived. Now, obviously, on that balancing test, the worse the issue is, the harder you're going to have to overcome. So for most of our clients, we're looking at somebody who has unlawful presence, maybe unlawful presence in a minor crime, right? I don't know why. Petty theft or possession of marijuana. It just seems to be very common. And we're looking to show that we're going to overcome that issue through this waiver. So what do we need to prove? We need to prove what's the purpose of the trip? Why are we coming? If there was a criminal issue, that you've been rehabilitated, that you lack immigrant intent, and then generally that you're not a risk to the US, national security, etc. Purpose of the trip, it's good to have a specific reason to come. Not just, I want to see my friends. I need to go to this wedding. I need to go to this business conference or meeting. My mom is having a medical concern, or I need a medical care from my specialist, right, who I was seeing for a while. Generally, we're going to be able to figure out some way, some reason to be able to come to the US. The main issue you're going to see is how do you show that you lack immigrant intent, especially if you grew up in the US, your friends are here, your family is here. How do you show that you lack immigrant intent? Well, really, it's about showing that you've established your life. This could be in getting a job, having a good lease, or maybe buying property or assets, making friends there, going to school there, whatever the case may be. If you're moving to a third country, not your original country, that you've obtained permanent residence in that country, or a work visa, or something in that country, and time. there's no rule, there's no set time, but in my mind, personally, I would think at least, a year or two, ideally two, would be necessary before you try to reapply. When it comes to non-immigrant visas, they look at your history of visa issuance. So if you get a denial the first time, it will make it harder. Unfortunately, even though it's not supposed to, each case is supposed to be reviewed case by case, it will negatively impact your future ability to get visas. So we want that first one to be successful. So it's worth waiting a little bit longer to get that first one, have it be successful, use it timely, leave and return to your country, and use that good history to apply for future applications. So for example, we use a strategy in one case where we're applying for just the visitor's visa for a limited purpose. And then our intention is for them to use that visitor's visa and waiver together in order to establish a good history, and then to apply for a type of work visa that would allow them to be in the US for a longer period. The concern being, if you're immediately seeking to come back, let's say for a 3-year visa, that doesn't really go towards showing you lack immigrant intent, right? So, there are different strategies you can use to show that you lack immigrant intent, but generally it's going to be showing the life you've established abroad and the time that it's been since you left. And I think I sped through that a little faster than I was expecting, but that's what I have. So should I cover anything else, or should we open it up for Q&A?
I think it would be really good to cover the age differences for DACA recipients and how the bar would apply for them. So like DACA recipients who had DACA since
Sure.
under the age of 18 versus those who obtained it over the age of 18.
Yeah, no, that's a great point. So what Tawhid is mentioning is that we talked about, in fact, let me go back in the slides. Okay, so we talked about how unlawful presence begins over 18. So if somebody obtained DACA and consistently held it since before they were 18, they would not have unlawful presence, meaning they would not be subject to the 3 or 10-year bar. So let's say somebody has no crimes, no misrepresentation, no grounds of inadmissibility when they leave the United States. Well, then for them, they would just need to be applying for, if needed, whatever visas in their country are required to enter the US. So if they are from Canada and they have no grounds of inadmissibility, they would just use their passport to enter. They're Canadian citizens. If they are from Cameroon, they would need to apply for a student visa, visitor's visa, something. Now, of course, depending on the country you're from, that may be easier or harder to obtain. But if you don't have any grounds of inadmissibility, there's no extra waiver or anything that you need to do outside of the normal visa. I guess while we're on that topic, I should mention, but we have to be paying attention to the dates that somebody had DACA, right? So if somebody had DACA from under 18, but there's a gap, we still need to calculate and add up that amount of time. So you are looking every single day, every single day counts. So if you got DACA from before you were 18, but then you got caught up in the prior administration's, kind of DACA mess, and you had a long period of time where your DACA application was pending, and it had expired, that amount of time counts against you, unfortunately. Did that kind of cover it?
Awesome, thank you, Rina. I think we could go answer. I think we could head towards the Q&A session.
Okay, let me stop the recording.
Great.